Our next speaker is Christopher Grant, and up next will be Patrick O'Neill. Good morning.
Good morning. Thank you, members of the board, for inviting me here today. My name is Chris Grant. I'm a partner at Schuchat, Cook & Werner in St. Louis, Missouri. I represent labor unions and members and workers. I've represented unions in numerous representation proceedings and unfair labor practice cases involving union elections. In addition, prior to becoming a lawyer, I helped organize a union in my workplace and then helped workers at other stores in the same retail chain to do the same. The board's proposed rules do much, in my mind, to eliminate unnecessary and wasteful litigation from the representation process and to focus on the primary goal, which is to allow employees to promptly exercise their right to choose whether they want union representation. The need for prompt elections is critical. The Supreme Court, over 40 years ago, in Barr versus Greyhound Corporation, noted that the union, unless an election can promptly be held to determine the choice of representation, runs the risk of impairment in strength and attrition and delay. More recently, in a slightly different circumstance in Fall River Dyeing, the court emphasized, quote, the significant interest of employees in being represented as soon as possible. One proposal I think is particularly important here, and that is the requirement that the employer provide a statement of issues and information on unit positions such as job titles. This proposal will remove the gamesmanship in our cases that commonly delay elections. In my experience, some employers refuse to provide its position and information not because they do not know, but to gain an advantage in litigation. And this inhibits the development of the record at the R hearing and proper resolution of those legal issues. I also want to speak to a broader problem. As a participant in our case process, as an employee in the past, as an organizer, and as an attorney, what strikes me is how stressful that process can be to employees. Delay only makes that process more stressful. Employees wonder when they'll get to vote, will their employer let them vote, and when a decision will be made. Employees also fear retaliation during this time. And when the effect of delay is to make the process more stressful, then employees are increasingly likely not to base their decision on careful consideration of the facts, but to respond emotionally to stop that stress. And that is, I think, contrary to the purpose of the Act. There have been some arguments about employers needing more time to voice their opinion and that employees cannot meaningfully exercise their right to vote without knowing the unit with complete finality. Now, in my experience, the employer almost always knows of the union activity pre-petition. For example, in a recent case I handled, ADB Utility Contractors, the employer's general manager told employees that he knew the employees were meeting with the union, and he fired several lead employee organizers before the petition was filed. Not surprisingly, in that case, the employer also abused the R case process. It refused to provide a statement as to the issues prior to the start of the hearing, and it made frivolous arguments about supervisors accounting for less than 20% of the unit. And this created delay during which the employer threatened, coerced, and fired more employees. I also want to say that the obvious, I think, which is the employer controls the workplace and is free to give its opinion on unionization at any time. And to say that unions benefit from months of supposed covert organizing while the employer cannot voice its opinion or view, I think ignores the imbalance in power between the employer and employee. Finally, defining the bargaining unit is not rocket science. For the most part, we're talking about relatively simple issues. Is the mechanic in the unit? There are two plant clericals. Are they out? Should we combine phlebotomists and lab technicians, our crew leaders, supervisors? Now, 20% rule draws an appropriate line. If fewer individuals are at issue, the complaint that I hear from employees is not, I can't meaningfully exercise my right to vote because I don't know if the mechanic is in the unit. Rather, the complaint is, why is there delay? What is happening? The perception is that the board is not controlling the process. The proposed rules, in my view, simply empower the regions and the hearing officers to properly manage and control the process and provide for prompt elections. Thank you.
Thank you for your comments. Are there any questions?
Do you have any views with respect to the portion of the proposed rule relating to blocking charges?
I did not prepare any comments on that. And I'm not quite sure. I know the board didn't really offer any opinion on that. In certain cases where there are significant unfair labor practices that hinder the ability to have a free and fair election, I think you have to allow for a blocking charge.
Would it make sense to have the election proceed and then have all the issues litigated after the election is held?
I do
to
not.
Avoid the delay in
I
the
think the
election.
union should be able to exercise its right to whether to go forward or not based upon its view of whether the unfair labor practices, and this is, I think, subject to the regional director's consideration too, but whether those unfair labor practices inhibit the ability for employees to exercise their free choice. When there's significant unfair labor practices, in my experience, involving the discharge of lead union employee organizers, threats to close the facility, threats to subcontract out work, that makes a free election impossible. If you have to litigate that post-election and then perhaps have the problem of a rerun election, there are multiple studies showing that the delay from the initial election to the rerun election costs unions. That it's very difficult, and the more time there is between the initial and the rerun election, the more likely the union is to lose.
I just had one other question. You indicated under our present system, when the parties, it's been my experience anyway, that our hearing officers and attorneys in the region are extraordinarily good at being able to solicit the position of the petitioner and of the employer with respect to the unit ahead of time. Do I understand you to say that you don't believe that to be the case, that the parties don't know at the time of the hearing what the issues are?
That is correct. There are multiple occasions where I participate in representation proceedings where the employer has flat out refused to provide what its statements would be prior to the start of the election. Typically how it works in Region 14, where I am, and is that, the hearing officer will attempt to solicit the views of the employer, whether there's a supervisory issue, what's the composition of the unit. There are, unfortunately, employers who will not provide that information prior to the start of the hearing, so you don't know, as a union, who to subpoena. You don't know what the issues are to be to properly prepare them. And so as a result, you go in there and you suddenly learn on the first day of the hearing that the employer's contesting that so-and-so is a supervisor. You don't have the ability to get them there. You don't have the ability to properly argue based upon the facts. And then as a result, you have a really bad record. And that makes it very difficult for the region, in my view, and the hearing officer and regional director to make a good decision.
So let me understand. How would that be changed under the rules, which don't require the statement of position until the day of the hearing in most instances, because of the relatively short time frame between the filing and the hearing?
My understanding is that the statement would be, as now, would be attempted to be provided or attempted to be solicited prior to the start of the hearing, days before. I suppose if the employer is absolutely refusing to provide it, I guess you don't have the statement of position until the day of the hearing, but at least you aren't caught midway through the hearing where the employer is raising a new issue.
Thank you.
Further? Thank you for coming here to share your thoughts with us.